and welcome to Highland O'Clock podcast. On this podcast, we basically capture experiences, practices, and lessons on land. My name is Rita Kemgisa, and this particular episode is brought to you by the Stand for Highland campaign, a global initiative that seeks to advance women land rights by closing that implementation gap that is there between law and practice. In Uganda, the campaign focuses on 5 advocacy priority issues, and one of them is on ensuring that women have access to land justice. And how the campaign does this is by ensuring it facilitates discussions around laws and policies that have a bearing on women's land rights. Today we shall be having a conversation around the marriage legislation in this country. It's quite a contentious issue because when you talk about marriage, it involves a lot of, emotions, love, and all that. But as Uganda, we've been in a struggle for the last 50 years to have a harmonized marriage law that is there to govern the marriage institution in this country. And I have the pleasure of having a very wonderful conversation with a very wonderful person. I prefer to call her a very fearless lawyer. She's a crusader of women's rights in this country. She is an advocate. And at one point, by the way, she was nominated as one of the best female lawyers that we do have in this country. Ladies and gentlemen, will come with me, Rose Wakikona. Like I mentioned, she's the lawyer. Then she's also the Deputy Executive Director of Women Probono Initiative. Rose, you're welcome to the podcast.
Thank you so much, Rita, for having me, and thank you for all those wonderful accolades. I'm very glad to be here to discuss marriage legislation, how far we've come as Uganda, and what more needs to be done.
But please go ahead and also further explain to yourself, to the people, how you would love to be known, because I might have said you're this fearless lawyer, crusader of human rights, and all that, but you might have a way that you would love the people to know you.
Yes, so my name is Rose Wakikona. I'm an advocate of the High Court, Court of Appeal, Supreme Court, and all subordinate courts they are under. That is my title. I've been practicing law since 2012, and the bulk of my work has been around advancing women's rights in Uganda and sexual reproductive health and rights. So that has been my day-to-day for the last 13 years. I am a feminist. So everything I do is always through the lens of feminism, making sure that women have voice, agency, that they're economically empowered, and that they have also bodily autonomy. Of course, for the past few years, that was 2024 and 2025, we've been fighting to advance the marriage bill through the 11th Parliament in the form that it is currently. Of course, we want some of the clauses to be amended and changed, but by and large seeking a total reform of family legislation in Uganda. So that is what we have been trying to do. I'm also the Deputy Executive Director for Women's Probono Initiative. Of course, our Women's Probono Initiative was established in 2018, and our duty is to make sure that only progressive laws and policies in Uganda are passed that advance women's rights.
Talking about those progressive laws and policies that advance women's land rights, why has it taken us so long to have just this one law on marriage that is there to govern this institution?
That is a question that has no one answer. Because at every turn there has been one excuse or the other, as to why the marriage legislation cannot be passed, as to why we cannot have a complete overhaul of the family laws that we currently have. The laws that we currently have were passed in 1904. They are colonial legislations that were left for us, so they are not ours. They are not laws that Parliament sat down, deliberated about, and then said, oh, this is what the Ugandans intend for marriages to look like, save for the Customary Registrations Act, which came around 1972. So we have this vestige or this remnant of the colonial era that we need to deal with, but somehow we have failed to overcome the colonial and the cultural and the traditions that surround what a family should look like.
So in marriage in Uganda, I would be right to say we are still being colonized even in the current marriages that we protract.
Exactly, because when you look at the Divorce Act 1904, the Mohammedan Act still in the colonial eras, the Hindu Marriages Act still in the colonial eras, and of course the Marriage Act, which the bulk of marriages fall under, still in the colonial eras. Updates have tried to be made on some of the provisions. They have been updated a bit through our jurisprudence, court decisions that have been made to try and update them to the current context, especially around issues of property rights, issues of how to determine grounds for divorce. They have tried to update in as much as they can. Succession laws, they have tried to update. Also, the 1995 Constitution under Article 31 has tried to update in terms of guaranteeing equality between men and women before, during, and upon dissolution. So there have been updates, but they are a bit sporadic and spread across. And for us, our recommendation has always been that we need to overhaul the whole system and bring it up to par with the current families that we have, the current marriages, and the current realities of our country.
Okay. Rose, currently the talk is, of course, on the marriage bill that was the marriage bill of 2022 that was tabled by Honorable Sarah Pendi. But people may not be alive to the history of how we got in here. She introduced the bill in 2022, but we have had a whole past of the struggle to have, a marriage law that would be there for once to, govern and rule the marriage institution in this country. But walk us through the journey. How did we get to the marriage bill of 2022? How did we start and how did we get here?
Yeah, people always think that somehow the women's movement appeared yesterday, but it didn't. This is a struggle that has been ongoing, and you can't talk about marriage reform and reform of the legislation without talking about the Kalema Report, which was passed in 1965. In 1964, when Uganda had just gotten independence, they set up a commission, and this commission was supposed to inquire about the status of marriage, divorce, and women in the country in familial relationships, and come up with recommendations on how they can update the laws at that time to make sure that they are conversant with Uganda's aspirations as a newly born country. And of course, this Kalema report came out with recommendations. At that time, they sounded so radical, and everyone was like, how can they suggest some of these things? But right now, we may look at them and say, some of these recommendations. So one of the things they were proposing was to prohibit polygamy and only allow marriage for monogamous situations. Because in their own definition, they were saying, there is no way that polygamy can guarantee equality between men and women. They were also proposing things of maybe if people live together for a particular number of years, then they should be constructed as if they are married, and courts should deal with them as if they were married. Of course, they were also proposing things of women can be able to apply to court for maintenance for their children, something which is guaranteed right now. But at that point, it wasn't. Recognition of illegitimate children, which at that point it wasn't. But right now, it's something that has literally been addressed. So it made a lot of recommendations. Also the fact that they should not allow people to divorce until they have spent at least 3 years in marriage, and not just one judge should determine a divorce. When someone petitions court for a divorce, they should have a committee that sits and then determine whether or not these parties should be separated. And of course, they also were recommending women should be given a share of the property of the husband when he dies, in case, and except if she remarries, then the rights would vitiate. So they were proposing a third of his estate should be given to her. So at that time, those recommendations were looked at as very, very progressive. And these are things that they tabled forward. Of course, recognizing that at that point, even customary marriages were not recognized in our law. So a lot of things happened, and eventually they passed the Customary Registration of Marriages Act. And when that one was passed, it meant that people who are married customarily can then be able to get married. Of course, they updated the Succession Act, and when they updated it, it meant that even wives were entitled to succeed from their husbands, something which wasn't happening before. Prior to that, culturally, it was your brother or your father who had to take over from you, but your wife couldn't inherit from you. So the Kalema report made a lot of recommendations that in piecemeal have been implemented through different legislations, but it still left a huge gap, because it had proposed that we update our marriage laws, but it was never done.
So how has the update been? So from the Kalema report, then we have the customary registration act.
Yes, so from there, the next attempt that was made was in 2003 when they tabled the domestic relations bill. At that time, people were in an uproar. So the domestic relations bill was carrying a bit of the recommendations of the Kalema report, but then it was going further to say, okay, we realize that polygamy is part of our culture, but we are requiring that you put a criteria for people to marry another spouse. You have to show that you are able to look after those extra spouses, that every spouse gets a separate resident, and that the spouses consent to you bringing another person into the marriage. So it had a lot of radical proposals that it made in terms of criminalizing widow inheritance, but also criminalizing the refund of bride price. So people were looking at that.
Inheritance was a good one.
It was a very good one. Its proposals were actually quite broad in the way that they looked at family life and didn't just narrow it to the scope of marriage, which is unfortunately not what is happening in the marriage bill, because what we are demanding for is an overhaul of the entire family laws, not just one tiny piece, and marriage is just one part of what family laws are.
Is a better, I would say, is a small unit of the family.
Yes,
it's much more than just marriage, which you contract between two people.
Exactly, because it affects so many other people, the children, the families, everyone around you. So everything needs to interconnect and feed into each other in order for it to be able to make sense. So the domestic relations bill was broader in its scope, but there was a lot of backlash. People are like, how dare you? Because they wanted, of course, to recognize cohabitation and look after people who treat them as if they are married. And people are like, no, 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 no. This is against our culture. It's against our traditions. How dare you try to bring all these criteria? So people said, okay, if this is it, let us first pack it. So they packed it until now, 2009, when they reintroduced.
For the domestic relations bill.
That was 2003.
The reason as why it's failed was because basically our culture, what we believe in as people.
Yes, yes. Because it tried to give extra protection for, especially, and I say this with a lot of consideration, for women in marriage. Because when you look at the hierarchy of the way marriage is constructed in our society, man is here, woman is here. So when you look at the way the law is constructed, the law is supposed to protect the most vulnerable in society. So when they put there these protections, the men look at it as almost losing power. So they are looking at it and saying, how can you guarantee this woman access to my property? How can you say she can sue me for maintenance of their children, that she can succeed me? Like all this, I have to decide. When I want, muwako. But stayagala, I don't give her. So they wanted to retain that power of decision making within marriages. And yet the law here is saying you are mandated. You are under an obligation. And this is the right a woman can go to court and claim. But the way the law was written was that it was neutral. So what is good for the goose is good for the gander. So if the tables are flipped and it is the woman in economic empowerment and the man is a bit low, he can equally seek the same.
This is happening a lot today. We have very many powerful women out there.
And they have their own, like myself, have my own properties, have my own man. I am rich. Now why?
Who are you? The man has nothing to say to you.
Exactly. So we shouldn't just imagine that these protections only extend to women. But at that time, because of women were disproportionately, men are supposed to provide. They were the ones with access to resources, money, property. The inheritance chain culturally runs through men. It does not run through women. So these guarantees, when they saw them, they are like, this cannot be. You're empowering women too much. So again, they tried to update. They came back in 2009 and said, okay, we listened to you in 2003 in the domestic relations bill. Now we have split. We have come with the marriage and divorce bill. Its proposals were not different from the domestic relations bill, but then they also split it and said, okay, the Mohammedan marriages will be dealt with in a separate law. So they proposed a separate legislation which was handling strictly Muslim marriages. This time round, they said, how can you add the word marriage and divorce in the same sentence? You women, what's wrong with you? So again, they chased the bill. So from 2009,
you make vows that what God has brought together,
no one should put asunder.
So why are you getting divorced?
Now the divorce, remove it. We cannot discuss marriage and at the same time cannot discuss divorce in the same language. But of course, for me as a lawyer who handles divorce matters, my take is that you can't have a divorce if there is no marriage. So the two go hand in hand. Where there is marriage, there will always be divorce. Whether you want it or not, that must always happen. So we must provide for divorce so that it doesn't impact grossly, especially the lives of the children who are within that marriage that is breaking.
So again in 2019, it is contested.
Again, that was in 2012. It was again contested. So now we move to right now where we have the marriage bill, again being reintroduced in another format. This time round, they have tried to do it in such a way that the first different times, it has been more of at the behest of the women's movement that was pushing for this legislation. This time round, we are being told that they worked with religious leaders to come up with a bill that is palatable to our religious views and to our traditions. Norms. So they consulted religious leaders, they consulted cultural leaders, and this is what they are proposing as a middle ground to satisfy all the stakeholders involved. And that's how we come to the marriage bill that we have right now.
So what is so different and unique about the current marriage bill that is before the Joint Committee of, I think, Gender and Legal and Parliamentary Affairs? What is so different and unique about it?
I think the most unique thing that it has, which is different, is that it allows for the distinction among the different types of marriages. Whereas the marriage bill, the marriage and divorce bill, and then the domestic relations bill just defined marriage as one thing. This one itemizes that you have a Christian marriage, you have a Mohammedan marriage, you have a Hindu marriage, you have a Baha'i marriage. So it allows people to define their marriages through the lens of their culture or through the lens of their religion. That is one of the biggest differences that we have in this current marriage bill. And it allows for you to maintain some of the nuanced differences between those. Like, for example, between the Mohammedan and the Christian, one is monogamous, one remains polygamous. So those nuanced differences.
And potentially polygamous.
Yes. So it maintains those nuanced differences, which alleviates the pain and the fears that maybe the culture and religious leaders were having in their hearts, that it completely erases the definition of marriage through the lens of culture and the lens of religion. So I think other than that, most of the provisions reflect the spirit of the prior bills.
And then, Rose, on that, another contentious issue that actually comes out or presents with the current bill is the clauses on property. And we have seen very many arguments from the men, even some women. And at some point, I've seen the president also write on social media that, you can't mix love and property. I would love to hear your thoughts on that.
You can't have love without property. For that is impossible. The biggest issues that women always face, and I'm a lawyer for women primarily, is land and family issues. When you go to family issues, it's always custody, maintenance, or divorce. And when you go to family court and you argue in cases of divorce, you argue in cases of maintenance, custody, the two biggest contentious issues is rarely whether people want to divorce. Usually by the time they come to you, they've already decided they want to divorce. But there are two things that remain contentious: property, children. So the law has to come in where the biggest contentions are. How do we protect children, and how do we guarantee?
Should be there to serve the interests of the people whom are they legislating for anyway.
Because when you go maybe to church, you say, what is mine is yours. What I have is now yours.
Then
so you're merging.
Married, you become one. Not two.
Yes, so you can't say we are married, we are one, but then this one's property is the other side, this one. So you cannot have a marriage without discussing issues of property. When you go before the church or you go before the mosque, you're swearing to become one. The two shall become one. What is mine is yours. So when you're defining some of those concepts, it means that you're talking about what is mine is what I have. What you have is your property. The assets that you have, the liabilities that you have. So you cannot go as an individual or your body, but then everything that is ascribed to you does not go into that particular marriage. We also have to note that marriage is not just a cultural or a religious institution. Marriage is a legal institution. It is the state which marries people. It is the state which divorces people. And when you marry, there are rights that are granted to you under the law. One of the rights that are granted to you as a spouse are property rights. And these are rights that you can claim in a court of law. Succession rights. These are rights that you can claim under the law. Consortium, parental rights. These are rights that you can claim under the law that people who are not married cannot be able to partake of. It makes me wonder, why then would you marry if there are no benefits that come along with the marriage? So one of the benefits...
You're marrying to reproduce children.
You can. But then also part of reproduction, you also have what they call production. When you look at the history of marriage and why it was set up, it is to stabilize reproduction, that is children, but also production, labor, things, assets, make sure that you continue with succession and people can be able... Exactly.
Because you're living on land, you're staying on this land. So
you're driving a car, like everything of yours has to have almost like a channel upon which it can continue. Because when you die, you're not leaving those things here. Someone has to take over. If no one is there to take over, the government will take over all that you have. So you cannot delink marriage from property, because marriage, according to the way we understand families, is at the foundation of what a family looks like. Two people come together and then start a small unit. And part of that unit is production, which means you must cater for property. And as I had already mentioned earlier, when you go to court, the two hottest issues that people are always contesting about are children and property. So that is the point at which the law has to come in and settle certain questions. And also when people enter marriage, they start looking at things in a collective manner. They stop looking at things in an individual manner. So it's like, tukolera family. We are working for the family. This one I have bought for the family. I am working for my children. So they cease looking at property individually and start looking at it in a communal way. So that means that our laws cannot therefore interpret such a relationship devoid of what a person is working for or what their aspirations are supposed to be. So that's why I don't think you can delink property from marriage. The two go hand in hand. It's just impossible.
What is the current bill, offering when it comes to, especially protecting, I would call them women's property and land rights? Because there is a lot of talk out there, and maybe we need to demystify this.
So what we currently have, maybe I can start from there, is that our laws do not provide for matrimonial property. They are completely silent. So it has been left up to the court to define how properties that are acquired during a marriage can then be distributed upon the dissolution. And when I'm talking about dissolution, I'm talking about death or divorce or separation, one of the three. So courts have come up with some sort of templates. The problem is that these templates are not universally applied. So this person maybe will gain a benefit, this one will not. Like, it depends on the judge that you appear for. So what we are pushing for is to create a harmonized standard so that whoever comes before the law, you are married, that is the standard that is applied to you. What I must emphasize is that the law doesn't protect women's rights to property. It protects spousal rights to property. So a husband and a wife, both of them, your right to property is protected. So if the wife has the property, they are protected. If the husband has the property, they are protected, and vice versa. So we should never just put it in a box and think that, oh, what they are doing is giving women men's property, or men are being given women's property. No, it is protecting your rights that are granted to you under the Marriage Act. those property rights that I had talked about. So the marriage bill is trying to create a standard by defining what is marital property. So matrimonial property, it's not automatic that everything you own as a spouse becomes matrimonial property, and we have to start from there. So court has two duties when it looks at matrimonial property and what is trying to be put in the marriage bill. The first one is to define what amongst the things the two of you have, or the four, depending on whether you're in a polygamous or a monogamous marriage, what amongst those things becomes matrimonial property. When it defines what becomes matrimonial property, then it decides how is it going to be distributed. Matrimonial property is property where you live, so where me and my spouse we live, where we raise our children, where we live every single day. That is our home. It doesn't matter if that property has been inherited, whether the property is registered in one person's names or it is in both your names, as long as you live there, that becomes matrimonial property. The second one.
So maybe on that, for my grassroots women. So that means if you're legally married,
yes,
and this is the house, this is the land where you derive a livelihood, a sustenance. In case of divorce, you're retaining that land.
No,
property.
where you live.
Yeah.
That the first criteria is where you live. So that is where you wake up every day, where your bed is, where you park your car or your bicycle or whatever it is, that where you sleep.
So don't talk about cars.
Well, like that is where your bed is and where your children are raised. That is the first criteria, where you live. Where are you living, if you're renting, that doesn't become matrimonial property. You must own it in some form of capacity. Usually people will succeed, parents will give them a gift. That becomes matrimonial property. The other one is if you buy it, maybe it's in one spouse's name, again that still remains matrimonial property. But if you live there with your family, it's matrimonial property. The second one is where you derive sustenance. So sustenance is maybe you have a plot of land, you farm it, you get your bananas, you get your beans, you get your maize, and you feed the family. Or where you have built rentals and you're getting income from there. So that land where you do income generating activity that supports the family, that one also becomes matrimonial property. The third one is where you decide that this property is going to be for the family, or it's going to be matrimonial property. So how we define it is if you've registered it in both your names, if you're both on the land agreement, where you have sent each other WhatsApp symbol, would have bought for the family land, or something like that. Then the court can say, okay, the intention was this was supposed to become matrimonial property. So those are the three elements that make up what becomes matrimonial property. Property that you succeed or where you inherit from your parents doesn't automatically become matrimonial property. Property that you buy in your own names does not automatically become matrimonial property. It must fit in those three criteria.
So where does this leave the people, currently in our society? People are marrying really young and they develop together. People call it twezimbi. We have worked together, we have got all this amassed all this wealth together, but then when that time reaches and things have failed, we have seen stories, we have seen, especially at the end of the day, it's the women who lose out, walking out of these marriages or walking out of these relationships without absolutely nothing. So and what does the bill prescribe when it comes to that?
And that's where some of the mistakes are being made, because you have to fulfill one of those three criteria in whatever way possible. So the encouragement that we always give to women and men who are in such relationships of twezimba, we are building ourselves, is that if you're making contributions to such a property, please do it in a way that you can trace the contribution. Use mobile money as the reference point, put we are building, or to purchase, or to buy bricks for this. Put a reference that can be traced back. Use the bank. Don't just go withdraw money and then pay a person in cash and then start making allegations later on. I even paid the 15 million, and then they are denying. I've never seen that money, she's lying. It becomes she said, he said. And the bill also just defines matrimonial property in the three criteria that I have said. So you have to be also very careful in the way that you're conducting your marriage. I know there has to be trust, there has to be the ability to, that openness that exists. But then you have to work at the back of your mind knowing that are my contributions being noted, especially if your name is not on the title or if it's not in the agreement. Then you have to be a little bit more extra in the way that you're conducting the business. But also, it is to encourage young couples. If you're buying land, why must it be in one person's names? Put it in both of your names so that both of you are ultimately protected. If you have an agreement, please put both your names and don't put yourself as a witness. Please put yourself as a seller or as a buyer so that you can cover all bases and make sure that you are protected under the law. Because we have a saying in law which says, equity aids the vigilant. You may come to me with very many stories, but if I can't prove them in court, then you won't be able to enforce a particular right that you may be able to have. So on the second part, after court has defined that this is matrimonial property, then they go on to the part that I was talking about, the distribution, or how much am I entitled to this particular property. Many people assume that if it's matrimonial property, I am entitled to 50%. That is a lie. It is not how the marriage bill is working or defining it, and it is not how court will define it. 50% only applies to property that is in both your names, where you own it jointly. Then their court will not do a lot. They'll say, but you own it jointly. Please, separate 50-50. But if it is not like that, and it is in one person's names, then court is going to consider your contributions, the financial ones. How much did you contribute? Oh, I put in 15 million, I put in 20, I bought bricks, I put a coat of paint, other people bought curtains. You know, all those contributions are going to be considered. The second part is your unpaid care work. I gave birth to children, I cleaned the house, I washed your shirts, I ironed them, I cooked food, all those things, they will consider them and also factor them into their contribution. But the other thing that the marriage bill is starting to introduce is also this thing where they look at the current status of the spouse. So for example, if I married this woman and they've been a housewife for 20 years, she has never held a job, her only job has been to look after me. So also that fact will be put into consideration when they are
very well,
exactly,
and you've been able to make more
yes.
money.
So of course court will say, but even if we say this woman, we leave her, we chase her from the house, where is she going to go? She has cooked for 40 years. Even her parents no longer remember how she looks like why exactly? So again, it will burden that, it will widen the scope of that contribution. So depending on how much you have contributed based on the factors and the parameters I have mentioned, then court will say, okay, maybe this one should be given 50% or 60% or 70% based on the facts that you have put before the court. So it's not that you get automatically 50%. You may only be entitled to 20 or even less, but all those factors need to be put in place. But then at least we establish a standard, especially within the marriage bill, on how to distribute matrimonial property.
Okay, Rose, as we come towards the tail end of this conversation that we're having today, and looking at the progressive provisions that the marriage bill offers, and having traced the history of how far we have come from the provisions that were made by the Kalema Commission in the 1960s to where we are now, 2025. To what extent do you think this current marriage bill will come to pass, and for once we shall live to see a marriage law? Because if you look at it from the conversation we are having, I think it has touched all the bits of the 1964, the recommendations that were made, the other recommendations that have been coming in from the other previous attempts we have had. When you peer into the future, to what extent do you see this bill passing? Do you have hope that we shall finally have a harmonized law that will govern this marriage institution in this country?
Maybe before I even try to answer that question, there is something I had forgotten that this new bill is introducing, that is liability to debt. So people have to note that now if you get liabilities as a couple, then you're both jointly liable for them. So if you live in a home and that home has a mortgage, then you're both So you're not just sharing assets.
First make it easy
Easy,
for us.
hey.
Let's put it for a loan. You lawyers.
If you get a loan,
the husband gets a loan, 500 million shillings.
yes.
Even
You
with
know,
a woman,
nowadays they cannot get a loan on a property without you consenting. So if you consent to that loan and it is over matrimonial property, then you're both jointly liable for that loan to pay
what
it
if I was
back.
not in the know that this man got this loan?
Now you have to go to court and say, I knew nothing about this, so that they can take away that requirement for you to be liable for that debt. But if you knew and you also benefited from that money, then you're both jointly liable for that debt. So even as they are distributing that matrimonial property, court will consider that, oh, there is a mortgage of 200 million, and they offset it before they divide the balance. So that is also another new element that it's introducing. Previously, it was just only assets that were being distributed, but now liabilities are also being catered for. Do we have hope? I think we've traveled a journey back from the Kalema report, where people were so appalled that a woman could inherit from her husband's property. And they were like, how dare she? And we've moved that journey, and now it is almost the norm that a legal wife automatically inherits and gets letters of administration and letters of probate as a first priority. No one even contests it anymore. Okay, we have a few ping pongs here and there where people are still trying to rear the ugly head of culture in such situations. But we've moved the journey. And people have come to terms slowly with the changing dynamics, especially of families. Nowadays, we have more women economically empowered, and they also now find that they have property to protect.
And they have men
they are looking after. So even it has been flipped. We have, instead of housewives, we are having house husbands. So people are beginning to open their eyes and saying, okay, maybe the way we had envisioned the marriage culturally, religiously, is not exactly how it's working out in the current regime of Uganda that we have. And we need a law that works for us currently as we have. So in many of our stakeholder engagements, we have not had as much backlash as it was in the early 2000s when we were fighting for the Domestic Relations Bill and the Marriage and Divorce Act, where everyone was like, oh my God. Now it's more of our points of pain are fewer than they were years ago. We have points of pain on things like asking parents to consent to the marriage, allowing also men to take on our names as women, also allowing us women to marry more than one husband. You know, our points of pain are not as big as they used to be. So I feel we have built consensus over a period of time, and now is a time as good as any to have the marriage bill passed. And we are also hopeful. We were hopeful in the 2010s. We are also hopeful right now. Of course, it doesn't help that we are coming in with a new set of parliamentarians. We don't know how they are thinking or what their politics is, or like whether they even have an inkling of what gender equality is or how far we've moved with this bill. The 11th Parliament, we had tried to do a bit of orientation, but now we face a challenge and we don't know who is
We're
coming.
getting back into the struggle with the new
with the new 12th Parliament. And you know, 70% of our parliamentarians always leave, and we have a new crop. So for me, my biggest worry is that we have to start afresh. We had moved a long journey, but now it feels as if we have to start anew and start afresh. But I feel as if this bill has more support than the previous bills that we have. So hopefully we'll get it passed. Lessons from other countries. Kenya has done it so well in terms of how it provides for people who are in polygamous relationships and how you can distribute property there. So again, it's to ask them, go back, benchmark and see how those people are doing it so that you can bring back that knowledge. So I would recommend the Kenya Marriage Act so that they can be able to carry some of those clauses, especially around property distribution for polygamy.
Thank you so much, Rose Wakikona, for hosting us. She has been our guest for today, and she has really been, very, I will say, kind of her to host us here at her offices here in TIDA. We don't take that for granted. She has given us the history of how far we have come in regards of having a marriage legislation here in the country. Currently, we are our hope is in the marriage bill that is currently before the joint committees of parliament. They have been out in the field gathering views of different stakeholders, from grassroots communities to religious leaders, cultural leaders, and people in various offices, CSO partners, name them. So we can only await to see what shall be presented in their report when they get to eventually table their report in Parliament. Your guess is good as ours, but we can only hope that for once this marriage bill shall be, passed, and we get to have a marriage law in this country. Until next time, my name is Rita Kemgisa. Bye-bye.